Good morning. Thank you for joining today's webinar. I'm going to give it 1 minute for everybody to go ahead and make sure we're logged on, and we'll start right at 11 a.m. All right, so I have it's 11 o'clock. I hope here at Eastern time. I hope you're all having a good morning. Thank you for joining today's webinar on Paraquat. My name is Julia Merritt, and I'm here with Matt Pettit from Beasley Allen, and we are on the Paraquat team. I was appointed by Judge Rosenstengel to be on the Plaintiffs Executive Committee in the Paraquat MDL, and I hope I'm going to be able to share some information about that with you today. Today's presentation will include 1 hour of CLE if you are a Georgia lawyer. So if you're a member of the Georgia Bar and you registered, Beasley Allen will submit that information to the Georgia Bar on your behalf, but please allow about a week or 2 for that to go through. So I just want to show you our Beasley Allen team. Ron Jones is the section head. I've already introduced myself and Matt Pettit, and Tricia Green and Ryan Krall are also attorneys working on the Paraquat case. So if you all have any questions after this seminar is over, you are welcome to contact any of the 5 of us, and we're happy to help out. So you can just email us or give us a call. So this is the overview of what we're going to be talking about today. Matt is going to start out with what Paraquat is. I'm going to talk about Parkinson's disease. I'm going to talk about the litigation, but the majority of this webinar is going to be about the nuts and bolts of client intake. We've been in the weeds on this for a while, it's a lot to take in, and I want to be able to answer your questions on client intake. There is a Q&A button on this webinar that you can click. Any questions that you have, type them up. And at the end of this webinar, Matt and I will answer any questions that you have. So now I'm going to turn it over to Matt to talk to you a little bit about what Paraquat is.
Thanks, Julia, and good morning to everyone, and thank you for taking time out of your schedule to join in this CLE. The purpose is really to provide a practical approach to these Paraquat cases and to get you some information that you need to know to start filing cases, or to even review cases. So I'll be going over a brief history of Paraquat today, including its primary uses and applications. And just a side note, this presentation will be available after, if you'd like to have some of the slides or just have the audio and video. So at the outset, it's important to state this is not a Roundup 2.0. Paraquat usage is smaller than Roundup usage. And just for comparison, there are currently about over 100,000 cases in the Roundup MDL. Currently in the Paraquat MDL, there's just under 300 filed cases. So in these cases, as Julia will discuss later on, intake criteria is just key. It's going to dictate whether or not you have a good case. So Paraquat is a highly toxic herbicide that is non-selective. Unlike other herbicides like Roundup, Paraquat will kill any foliage that it comes in contact with. It's not just used for simple weed control like users would use on a residential property. Rather, it's mainly used for no-till farming or industrial applications. Interestingly, Paraquat was used by the US government in the 60s to eradicate poppy and marijuana fields. So that gives a good indication of its strength. It's a total kill, and it will kill almost any plant that it touches. A key difference between Paraquat and other herbicides is that Paraquat is a restricted use pesticide, meaning that it is only available by an individual who has a restricted use license. While the EPA controls the classification for restricted use pesticides, state agencies handle the actual licensing. Many states will have a restricted use pesticide database that shows who in the state has a license to apply restricted use pesticides. This is helpful when you're trying to vet a client's case, but depending on your state, the records may not go back as far as they need to. And also, some of these databases only show restricted use pesticides. It doesn't break it down into what particular restricted pesticide the applicator has a license for. So it's more of like a cross-check than a good primary source. So this herbicide is not widely available as Roundup or other products that can be picked up at your local hardware store. The one exception would be in farming communities. Paraquat is usually available at the local co-ops and similar stores. Originally, Paraquat could be applied by anyone, so it was very common for a farm owner or orchard owner to be the holder of the license while the employees of the farm would be the actual applicators. In 2018, I'm sorry, this changed, and now Paraquat can only be applied by the individual who holds the license. And I believe that there is a certification that you must do, and you must recertify with a test every 3 years or so, if I believe correctly. So let's go to the next slide. So Paraquat is such a highly toxic herbicide that it has a total ban in 32 countries and partial bans in over 60 countries. It's totally banned in China, and it's totally banned in Switzerland, which is the headquarters of defendant Syngenta. Paraquat first became commercially available in the United States in 1964. So this will be the start date for any of your clients. If they say anything prior to this, then you might need to ask some follow-up questions because it just simply wasn't available until 64. At first, Chevron had an exclusive deal to sell Paraquat in the United States under the trade name Remaxon with Syngenta's then iteration, which is called Imperial Chemical Industries, or ICI. This exclusive deal ended in approximately 1986, and Chevron stopped selling Paraquat altogether in the United States. Chevron's counsel at the moment are they're going through file complaints, and they're simply checking usage dates. And if client or plaintiffs are citing anything post this 86 date, Chevron is in the process of filing motions to dismiss to get them out of those cases. So be mindful of this when you're selecting your defendant's trigger case. One thing to keep in mind when you're discussing Paraquat usage with a potential client is that Paraquat is dyed a very vibrant blue and has an odor additive to avoid any kind of unintentional consumption. These facts we have found can be helpful in weeding out cases that were probably not using Paraquat. Paraquat is sold in a granular form, and it can be sold in a concentrate. And from what we have seen so far, the farmers who use Paraquat may not remember the specific brand that they use, but they distinctly remember the color and the smell. We can go to the next slide. So even though Paraquat is a restricted use herbicide, it is heavily used within its industry. As you can see from this map, since 2014, its use has consistently been on the rise. Many say that its use has increased recently due to the plants becoming more resistant to glyphosate-based herbicides. California, Texas, Illinois, and South Dakota are some of the primary states where Paraquat usage is the heaviest. We can go next slide. So this, like I said, Remaxon is the name brand, and Paraquat is kind of the generic term. So this list kind of just shows you, this isn't even a complete list, but this shows you just how many different iterations of Paraquat is on the market currently. So you can go to the next slide. So Paraquat's primary use is on soybeans, corn, and cotton. Paraquat is also heavily used in California in the wine industry on the grapes. There are also several citrus trees that are resistant to paraquat. They are the exception. And so these orchard farmers can actually spray paraquat on the citrus trees to remove weeds and things surrounding it without killing the tree or its foliage. Paraquat can also be used as a desiccant or drying agent on crops like cotton, tobacco, and even marijuana. And so usually the farmer will spray this towards the end of the season when these crops are ready to be harvested. It will make harvesting a little bit easier. We have gotten a few clients that have tried to link marijuana usage to their Parkinson's and Paraquat, and from our perspective, it's just such a hard link to make. So we're kind of passing on those cases, but they're out there. Paraquat also has applications in the railroad industry where boxcars would just travel down the rail line and spray it on either side of the tracks to burn down and total kill any of the weeds along either side. And after talking with farmers and license holders, we've seen that Paraquat is not an herbicide that is used monthly, but rather it's used selectively and at certain points in the growing season. So when reviewing cases, keep the potential client's use in mind. If they are claiming to be spraying monthly or even weekly, and they were not some kind of farmhand working at multiple farms, then it is questionable if Paraquat was actually being used. And I think that's, you're on the next slide.
Okay, thanks, Matt. And I'm going to talk a little bit about Parkinson's disease now. So Parkinson's disease is one diagnosis underneath the Parkinsonism umbrella. So Parkinsonism is what I consider an umbrella of symptoms, and there are a lot of different diagnoses that go under that umbrella. Another example would be Lewy body's disease or manganese-induced Parkinsonism. So it is important that we make sure that we're accepting cases with Parkinson's disease or Parkinson's disease-like symptoms. So Parkinson's disease is incurable. It's a progressive disease, and it is a movement disorder condition. And it's interesting that it's not actually firmly diagnosable until death, and that's because you need to have an autopsy. But of course, we all know people who have been diagnosed with Parkinson's disease, and that's because it's a differential diagnosis based on the symptoms. And this illustration on the slide lays out some of the symptoms. So a lot of people have a tremor, but it is not a requirement of Parkinson's disease to have a tremor. In fact, 20% of people with Parkinson's disease do not have a tremor. So it's just a myriad of symptoms. And we have found that the best way to get a proper diagnosis of Parkinson's disease is to find a neurologist who has a majority of clients who have Parkinson's disease. If your neurologist only has 10-20% of their patients with Parkinson's disease, they may not be the best neurologist for your client. The other option is to find a movement disorder specialist. That is a neurologist who has a specialty in Parkinsonism. And we've had a lot of clients who originally had a series of Parkinsonism-like symptoms, but not a Parkinson's disease diagnosis until they have been to a movement disorder specialist who then gave them an accurate diagnosis. And that's best for the client too. They need to be properly diagnosed. So Another interesting symptom of Parkinson's disease is called micrographia, and that's small handwriting. And there are two different types of that. It can either start out large and get smaller by the end of the line, or start out really small. Parkinson's disease it's a lot of the symptoms are smallness. My stepdad has Parkinson's disease, and he's had it since I can remember, for at least 20 years. And when he goes to therapies, the therapy is to do big things, big movements, and it feels to them like they're doing awkward big things when they take larger steps, talk louder, use larger hand gestures. And so that's one of the therapies that is beneficial to Parkinson's disease. So I'm going to talk a lot more about the diagnosis of Parkinson's disease in the client intake section, but that's a good summary. And also to let you know about how Paraquat causes or induces Parkinsonism and Parkinson-like symptoms. It crosses the blood-brain barrier and actually gets into the brain. So the mechanism in the MDL, we are not focusing on the mechanism, whether it's by skin contact or by breathing. It almost doesn't matter, the mechanism, because what we know is it is in the brain. And so it gets there. So I'm going to talk a little bit about the litigation status now. Cases have been filed in both state courts and federal courts across the country. There's a list here on your screen, which is Illinois, West Virginia, Missouri, Mississippi, Alabama, California, and Minnesota. The majority of the state cases are filed in either Illinois or California. There are approximately, I believe, this is an estimate, so don't hold me to it, but I believe 30 cases in California. And there is a JCCP. Leadership has not been worked out in California. There is a hearing for the JCCP tomorrow to discuss leadership. So that is being worked on right now. And of course, you know that an MDL was formed in the Southern District of Illinois. That was formed on June 8, 2021. And Judge Nancy J. Rosenstengel is our judge. She is the chief judge of the Southern District of Illinois. And I'll tell you what, she is going to be great for this case. I really feel thankful that she's our judge. She has just taken this case and is pushing it. We're on a rocket docket. We have a trial date already set for November 15, 2022. And we all know that that's what gets a case moving, is if we all have to prepare for trial. So one of the reasons that we are able to have a trial date in November 2022 is because there was existing litigation in the state court of Illinois in St. Clair County. That litigation was brought by plaintiff's attorney Steve Tillery. And there were about, less than 10 cases, I believe about 7. And one of those cases, the plaintiff's name is Hoffman. And so I'm going to talk a little bit about the Hoffman litigation. That case is currently in settlement discussions, but the settlement has not been finalized. So in the Hoffman litigation, the litigation process was complete. They did a complete discovery, and they did over 70 depositions. Tons of documents were produced. Several terabytes of documents were produced by Syngenta and Chevron. And so Judge Rosenstengel in the MDL ordered that all of the discovery in the state court Hoffman case be produced in the MDL. That you can read that order on the docket. It is all of the depositions that have occurred in all of the exhibits. There are some issues about work product and confidentiality and privilege that are being worked out, but a lot of those documents have been produced. They're being summarized. And then, in the MDL, that means that we do not need to recreate the wheel. There are some stipulations that were entered in the Hoffman litigation about successor liability that we are trying to get worked out in the MDL as well. So, we're not having to recreate the wheel. I feel like that was really forward thinking of Judge Rosenstengel to order that, and for us to be able to, not have to relitigate the entire case that's already been litigated. But of course, there's still going to be a lot of work to do. We're going to have to figure out which depositions still need to be taken, which experts we need to retain. It's still a lot of work to be done. Also in the MDL, a Paraquat assessment questionnaire has been finalized. It's called the PAQ. And that is going to be, it's a great guide for client intake. It is on the docket. You can download it. And right now it's a physical, sheet of paper. You can send it to your clients. But eventually it's going to be an online drop-down box format that is going to be managed by a third-party contractor, and each of the clients will fill it out with our assistance. Of course, it's going to be a lot of very detailed information, but the parties worked together to finalize that, and it has been ordered and entered. Also in the MDL, a special master was appointed. Her name is Randy Ellis, and she was also a special master with Judge Rosenstengel in the Deep Coat MDL. So she has been great. She's having weekly conversations with leadership on both sides. She is helping work out things such as the PAQ. And it's been a real benefit to the litigation. Randy Ellis is really a neat woman, and she's very on top of the litigation, and is able to spend a lot of time working out discovery issues and keeping the conversation going. So there will also be a plaintiff fact sheet, PFS, but that is probably going to be reserved for those bellwether cases or the potential bellwether cases. So I'm not sure exactly how long that's going to take, but it's in process. And we're also working on a defendant's fact sheet. And so that's been an interesting process, and it's in the works. So now I'm going to go to client intake, the nuts and bolts of case screening. This is unlike any other mass tort that any of us at Beasley Allen have worked on. I know every mass tort is different, but this one's different too. So Judge Rosenstengel and Randy Ellis and leadership in the MDL have really requested that plaintiffs file their cases. As Matt said, and I think as of this morning, there might be like 306 or 308 cases filed in the MDL. And we know there are a lot more out there. So we're encouraging plaintiffs to go ahead and file with one caveat. And this is a very important caveat: file the right cases. And that's where this push and pull is coming in, because the case selection process is very challenging. And that's kind of what I want to be talking to you guys about. So there are really two issues for case intake. There's the diagnosis issue, and then there is the exposure issue. So I'll talk about diagnosis first. As I talked to you about before, Parkinson's disease is a specific set of symptoms. So if you have a client or a potential client who has tremors and is taking the prescription levodopa, but doesn't have a Parkinson's diagnosis, I encourage you to recommend them finding a movement disorder specialist to get the proper diagnosis. And as I said before, this is beneficial to the client so they can get the treatment that they need. They can get the therapies that they need. There are a lot of people out there that we've learned that don't have the proper diagnosis. And so guiding them and helping them into finding the right doctor in their area is vital. A lot of these people, it's hard because there might not be a movement disorder specialist within 50 or 100 miles, but it's really important to get your client to go and see the specialist that they need to see to get the proper diagnosis. So I guess that leads to the point that just because your client doesn't have a Parkinson's diagnosis, that doesn't mean that that isn't a good case. It means it needs more work. And, a term that leadership in the MDL has used that I really like is docket control and diagnosis control. So this is what I'm talking about with diagnosis control is you really have to take each case individually, look through their medical records, Parkinson's-like symptoms. Okay, how long has this been going on? And see if we can get them the right diagnosis. So a great resource is the Parkinson's Disease Foundation. Our intake team is calling them on a daily basis saying, hey, we have a client in Missouri who has Parkinson's-like symptoms, but hasn't gotten the proper diagnosis. And they will tell us, oh, well, here's a neurologist who has that large amount of patient issues with Parkinson's disease. So they're a good neurologist to go to, or here's a movement disorder specialist in the area. So you'll also see in your client intake that people with Parkinson's disease have a hard time communicating. It's really hard to understand them. They are a lot of times quiet, and the micrographia that I talked about with the small handwriting makes intake questionnaires that they fill out really hard to read. So it takes a lot of patience. It takes a lot of time. And maybe finding a family member who can be the kind of phone presence has been really good for us. A child or, an adult, not a child, but an adult child of a patient with Parkinson's disease can oftentimes be a spokesperson for that person if they're very hard to understand or if it's very hard to read their writing. So that's kind of the initial screening process for diagnosis. And now I'm going to move on to exposure. So as Matt said, this is not a Roundup 2.0. Exposure history is very different in these Paraquat cases. We have found the way that I'm trying to think about it in terms of intake is a three tiers. Tier 1 is applicators. Tier 2 is what we're calling informally non-applicators. And tier 3 is bystander. The MDL leadership has changed the terminology. They do not want drift to be used in this litigation. So the term is bystander, and I'm going to go through each of those tiers and kind of what we're seeing. So let me get a quick sip of water. So the applicator cases, as Matt told you, you need to have a license in order to purchase or apply Paraquat. So that is a major overstatement in terms of client intake. We are not requiring our clients to have a license, and that is a universal truth for leadership in the MDL. We have all decided that if you require a license, it's only benefiting the defendant, and it's also not an accurate depiction of who's really using this product. So if you have a farming family One person they can actually hire a contractor to come onto their farm and spray the paraquat. And that contractor, a chemical spraying company might have one person who has a license and 15 employees or whatever. Those employees don't necessarily have the license, and those are the people who are actively spraying the paraquat. So, don't get focused on whether your potential client has a license, because that is only going to benefit the defendants by saying, only license holders can be plaintiffs. That's not what's going to happen here. It's just like the burden of proof in any other court of law. Is your client willing to state under oath that they used paraquat? And then obviously we need corroborating evidence, such as, tell us why you used it. Tell us what type of crop you used it on. What season did you use it? What color was it? What did it smell like? And that is the way to really drill down on your client as to whether they used paraquat. And as I said, this is for the gold standard applicator cases, which are the only cases that we are currently filing right now are those who actively applied paraquat and have Parkinson's disease. So there are a lot of ways that you can kind of, I feel like I've said weed out. This is so many times, weed out, which we're talking about a weed killer. So sorry, it's a bad pun, but you can weed out the clients that are, I don't think that they're actively trying to not tell the truth, but they may have a faulty memory of what they really used. So these are some of the questions that we like to ask is, where did you buy it? And if they say Home Depot, then we know that's not paraquat. We say, where did you use it? Oh, I sprayed it on my vegetable garden in the backyard. No, you didn't. You didn't, because it would kill all the vegetables in your garden, first of all, and it's a commercial total kill application. So you're not going to use it in your backyard. This is where you've got, thousands of acres of corn or peanuts or soy, and it is, sprayed on the back of a tractor or from crop dusters. So people who think that they sprayed it in their backyard, it's not just unlikely, it's just not possible. So, and also talking about the toxicity of paraquat, I said it's a total kill, and Matt talked a lot about this, but paraquat is so deadly that one thimble full of drinking it, ingesting it, can be used as a suicide agent. People have used this to kill themselves. That's how horrible this product is. It's just highly toxic, and it's interesting because there is a warning not to drink it, but there is no warning about breathing it in or using PPE. So it's kind of sad but true. So let's talk about the second tier. And this is what we're calling the non-applicators. So paraquat is a heavy chemical. So when it's sprayed, it sinks. It's not like Roundup in terms of drifting, blowing. It has a surfactant that attaches and binds to the soil or the whatever weed or plant, but it doesn't have the same qualities of drift that we've seen for Roundup and other herbicides. So for these non-applicator cases, this is what I'm considering like somebody who stood underneath the applicator, so for example, in crop dusting, a lot of times you've got a person standing on the field with two flags. saying, this is where to dump the Paraquat, and they get saturated in it. That is a really strong non-applicator case. Somebody who sits with their father on the tractor while he sprayed, somebody who year after year lived on the farm where the Paraquat was sprayed and stood out in the field while it was being sprayed. So I'm talking about a tactile touch of the Paraquat. And so that leads me to the third tier, which is the bystander cases, or the old drift cases. So those cases are, I lived 2 miles from the farm, and I used to go outside and watch the crop dusters, and I think they sprayed Paraquat. Those, unfortunately, and it's hard because a lot of these people have Parkinson's disease. It is possible that it was caused by Paraquat. I don't doubt that it was caused by Paraquat, but the science just isn't there to prove that right now. So unfortunately, we're just not able to accept those cases, and we're not filing any of the drift cases. The drift or the bystander cases. So that's kind of the 3 tiers in a nutshell. And, I would just really encourage you to, for people who don't know whether they used Paraquat, but they were either applicators or non-applicators that had some sort of a direct exposure to Paraquat, what they believe was Paraquat, some sort of a chemical. There are some interesting ways that you can go about researching whether it was really Paraquat. You can call their employer and ask if they used Paraquat, or ask who had the license, or their former employer. So some red flags to see of people who think that they sprayed Paraquat but weren't sure is, again, drill down on why they were using Paraquat. A lot of people think that they used it on golf courses. That, first of all, it would kill all the grass. And I haven't come across a case with someone who used it on golf courses that it was actually accurate, but I talked to someone yesterday who asked, I wonder if they sprayed it, on the sand traps or on the edges where they wanted to kill everything. I don't know. I'm not saying no. I'm saying I would need to drill down further on that, ask more questions, find out if it was used. I just can't imagine why they wouldn't use Roundup for that, or a different herbicide, because this is so toxic. And the chance of it killing the grass, which is so important on a golf course, seems kind of high to me. So also Matt talked about Paraquat resistant citrus trees. So another way that Paraquat is used is, let's take an orange orchard down in Florida as an example. So it could be sprayed on the bark of the trees. If the Paraquat were sprayed on the actual citrus fruit or the leaves of the trees, it would kill them. But some citrus trees have become Paraquat resistant through the bark. So what is done there is, they will go down and spray the base of the citrus trees and kill all of the weeds down at the bottom. And so that makes it easier for people to go and place ladders and pick the citrus if there are no weeds down at the bottom. And so that is a real use. Vineyards out in California is a use. Avocado trees, we're learning that's a use. And so it's important to, find out what crop, why were they using it, what time of year. If somebody said, I sprayed it on my strawberries, no, you didn't. So, as I said, just keep going. I see one question here that's a great question. What about a helicopter spraying over power line right-of-ways? That's a very good possibility. Power substations are another place where where Paraquat has been used. So yes, that's a good one. Railroad right-of-ways, as Matt pointed out. It was put on the back, Paraquat was put on the back of a railroad car and just sprayed over, thousands of miles of railway. So the tricky part about that is who would really be exposed to that. It's not going, now we're going back to the tier 1, 2, and 3. Someone who lived close to the railroad is not going to be an applicator or a non-applicator case. That's going to be a bystander case, and that's not going to have the proof that we need. So we do have a couple of clients who actually cleaned out the tanks and the railroad cars and physically got Paraquat on their bodies. That is a very good non-applicator case. And why the distinction between applicator and non-applicator? And it's really frequency of exposure. So, the more times people were exposed, if they're applicators, this was their job, they probably did it several times a year. If they're a non-applicator and they just get exposed once, that's just a lower level of proof. And that's kind of where we're coming from on that. Let's see. Oh, I haven't talked much about comorbidities, pre-existing conditions, things that are less likely for causation issues. Exposure to other chemicals is very common, and we are learning that there is really a synergy between exposure to many chemicals, and that is not anything that's going to stop us from taking a case. Crop dusters, applicators, chemical applicators, they spray tons of different chemicals. And just because they sprayed other chemicals is not going to be a reason that we don't accept that case. So that's fine. Significant head trauma, ask your client a lot of different questions about if there was significant head trauma. That can be a way to induce Parkinson-like symptoms. Again, this is when you work with your movement disorder specialist and your neurologist to figure out if we can get some more information on what that head injury was like. Welding, significant welding history with metals can be a problem. A lot of farmers do their own welding to fix their own equipment and their fences, and that's fine. Just be aware of it. Ask the questions. It's going to come up in the plaintiff's assessment questionnaire, the PAQ. So, just don't be taken by surprise by that. Manganese exposure. Again, it's going to be an issue, but I wouldn't reject a case because your client has had manganese exposure. And the reason that manganese is an issue is because of manganese-induced Parkinsonism. So, but again, this is all developing science. We are still working with experts and epidemiologists, and so there's a lot that still needs to be learned about that, but it's just something to be aware of. Another thing that's important is where your client was exposed. So if you have a client that was exposed in California, you might want to consider filing in California State Court. We'd be happy to work with you or help you talk through those types of issues. The state of exposure is pretty important. And when you file in the MDL, you need to allege the state law where the exposure occurred. So, you're going to have to do your research on the statute of limitations, the statute of repose, whether there is a private public nuisance, a private cause of action for a public nuisance claim. There is not a master complaint, and there likely is not going to be a master complaint in the MDL. So complaint drafting is pretty complex. there's not a short form or a long form complaint at this point, and I just don't think it's going to get there. So each plaintiff's attorney has their own complaint, and everybody's kind of drafting separately. Motions to dismiss have started. We're currently working through that. One other issue I failed to mention earlier that I just thought about was service. So in service, there's an international defendant, Syngenta AG, and you have to go through The Hague. And oh my gosh, it is a hassle and it's expensive, several $1,000s. You have to get your complaint translated, and then it can take up to 16 weeks or more for service once it's been translated, and it costs, as I said, a couple $1,000s. So the leadership in the MDL has filed a motion to try to get the court to make an order that Syngenta AG accept service, and the fact that they already have notice, they are not willing to accept service. Now, as for Chevron and Syngenta, the American companies, they will waive service if you request it, but it does take them a couple of weeks to get back to you. So we have just been issuing service of process on Syngenta and Chevron, the national corporations. I see a question here: how long between exposure and onset of symptoms? We're seeing about 10 years is about right, minimum. So, a lot of these people applied Paraquat in their 20s, and now, they're a lot older. They applied it in the 70s or in the 80s, and now, they're 60 or 70 years old. We are not using age as a factor in terms of, like, if a client is 80 years old, we are still accepting those cases. But yeah, if they sprayed Paraquat for the first time last year and now have Parkinson's like symptoms, that's pretty unlikely. So I would just look into that a lot further. So I have a couple of other questions, and Matt, I'm hoping that you can help out with some of these. One question is, when did licensing become required in the United States? Do you know that?
Yeah, as far as I know, as soon as it was introduced, it was classified as a restricted use, and I think formally its application was approved in '97. So ever since the 60s, most people will have had a license to buy it. And what we have been finding, it's very common, especially in these rural farming communities, where an individual would go to a neighbor who had a license and they would just borrow some and then apply it on their own farm. So like Julia said, licensing is not a de facto reason to accept a case, but it's a good way to try to vet a case. And so that's how we're using it.
That's right. I see the next question: which platform will be hosting the PAQ? I wish I knew. I'm not sure yet. It hasn't been implemented yet. A court order hasn't been issued on implementing the PAQ yet. So I only have the hard copy and don't know about the host yet. Another question, and now's a great time to ask questions. I'm finished with the majority of my presentation, so I'm just going to be running through questions now. So please ask away. Is there a plaintiff's attorneys working group we can join to collaborate and ask questions? I do not know of one. You are welcome to contact me and ask questions anytime, or anybody at Beasley Allen on the Paraquat team. So, I know that there's going to be, for example, at MTMP, it's a Mass Tort conference out in Vegas in mid-October. There are going to be 2 sessions on Paraquat. So, that's going to be another informational source. I'll be speaking, I'll be on the panel for the second second issue at the MTMP conference. So, and if you come to MTMP, come out, say hi to me and say hi to Matt. We'll both be there. Ron will be there as well. And we're happy to, chit chat, answer any questions there. Okay, I answered the question about exposure and onset of symptoms, approximately 10 years. Are there any Arkansas cases filed? Not that I am aware of. Matt, do you know if there's any usage in Arkansas from your knowledge?
Yes, we actually just filed this past week some Arkansas cases.
Okay, great. So we didn't file them in state court. We filed them in MDL alleging exposure in Arkansas.
And I guess that's a good point. I don't know if we said it directly, but there is a direct filing order in place for our the MDL. So you don't have to worry about filing and then transferring and all that kind of stuff. You can direct file. One thing that we're advising, it's common in a lot of the complaints, if you browse the docket, you need to make sure you have some lexicon language in there, because especially after what happened with the Jewel litigation, leadership is trying to be proactive with that, and we're trying to get the defendants on the front end to discuss lexicon rather than on the back end when we're looking at bellwethers and they're trying to eliminate 90% of the cases, like what happened in Jewel. So that's just one thing to be aware of while you're drafting.
Yes. Further speaking to drafting, I see someone ask a question. Does leadership have an exemplar complaint they would like us to use as a guide if we file a case? I wish. No. So we are just drafting our own complaints. You can look on the docket, pull cases, pull complaints and use them as a go by, but it's kind of the Wild West right now out there with complaint drafting. So statute of limitations, I see two questions out here. What are you using for statute of limitation date, knew or should have known? And can you speak to the statute of limitation analysis? So it's a state by state issue. Every state has a separate statute of limitations. Some are really strict, some are not. And if you have multiple state exposure, I would definitely do a statute of limitations analysis and, make the claim and the causes of action for the state that has the best statute of limitations. But, we're all in the executive committee, we're going to fight over statute of limitations because this is new science. Causation is new information. So, we're going to have to put up a fight for that. Syngenta actually has a website about why Paraquat does not cause Parkinson's disease. So, I think that there is some, fraudulent tolling stuff that we're going to allege, but we're just not there yet. So, statute of limitation, it is an issue. We kind of have a pin in it, and we're going to keep looking into it later. Matt, do you have anything else you want to add on statute?
No, I mean, it's just mainly been, we've had clients that have had exposures in multiple states, and unfortunately, it's just, choice of law analysis, seeing which one has better statutes of limitations, repose, discovery statutes, which state has a better various causes of actions. We're finding it key to try to include public nuisance and Deceptive Trade Practices Act if the state has it. So those are all just things to keep in mind. It's work, but it's what we have to do at the moment.
Mm-hmm. Is there a list for who had a license? How do we find out if there was a license? This is a great question. No, there's not a list. Again, it's a state by state issue. We've analyzed all of the states in the Southeast on this issue. And, there could be a list of all people with a restricted use license. But that could be one of, I forget how many chemicals, Matt, but hundreds.
Oh, it's over, 176. So like I said, it's kind of hard to use that to eliminate cases, but it's good for like a cross-reference. license.
Exactly. Yes. So, you could see, did this employer have a restricted use license? But it's a cross-reference, but it's not a way to find out if your client actively used Paraquat.
Right.
All right, let's see. Matt, are there any Mississippi cases that we filed?
Yes. Well, yeah. So we have filed Mississippi cases, and then actually before the MDL was formed, there were some attorneys trying to push for Mississippi to be the location of the MDL because Mississippi surprisingly has a very high use of this Paraquat. And so there are Mississippi cases filed. They're on the docket in the MDL.
Okay. And Matt, we have the same question about North Carolina.
So I think I can answer two questions at once. I see this, there's one with someone asking what states are the American defendants located?
Yes.
And so Syngenta Crop Protection is Syngenta's domestic arm in the States. And they are headquartered, they are headquartered in California, but they're incorporated in Pennsylvania, I believe. And then they're incorporated in North Carolina. Chevron is headquartered in California. So it's California and North Carolina. Those could be to destroy diversity. And then there are some cases that have been filed in North Carolina as well. We haven't followed any yet, but North Carolina does not have a public nuisance from what I believe. So we've been trying to stay away from that state.
All right, I'm going to read this question. Do you ask your treating neurologists about whether they believe that Paraquat is a risk factor for Parkinson's disease, even though the treater may not be used for causation proof? If they're deposed, the questions will be asked by defense counsel. Any thoughts about finding treaters who will consider Paraquat as a risk factor? It's a great question. Some of our medical records, our clients' medical records actually say, history of Paraquat exposure. So some treaters are aware. And yes, I agree that we need to find treaters who know about this and educate neurologists. And I mean, gosh, this tort is growing so fast, and more neurologists are learning about it. So, but yes, I agree. The defendants are going to drill down on that. And especially if there are other risk factors that we talked about earlier, such as head injury, manganese exposure, welding, so it's good if your client talks to their doctor about their Paraquat exposure. I think that's really important. Matt, you want to take this one? The question is, how do you get state applicator lists, public record requests, or are they available online?
So once again, it's kind of state by state. As Julia said, we did an in-house analysis of the southeastern states, and many of those states had a website that you could find a Excel spreadsheet that's downloadable that will have the information. Now, since it's state by state, some maintain better records than others. There were certain states, and I'm sorry, I can't remember off the top of my head, that would have first name, last name, address, years of holding the license, and county. So that was really good information. But then you have other databases that will just simply show the number of restricted use pesticides in a particular county. So it varies widely. And so that's why we're using it as a cross-check and not a main source. And speaking more to what Julia brought up earlier, we're not trying to provide a license as a requirement to bring the case, because that just boxes us in too much. So simply what's being done in the MDL is similar to what was being done in the Roundup MDL, where we are going to get an affidavit signed by the client stating their use. And that's going to be our evidence. It's not going to be providing a license. It's not going to be providing an exhaustive list of receipts. And so it's really just finding those cases that you can talk with the client and have a really good faith belief that the client used Paraquat.
So here's the last question that we have, and it's 11:59, so this has worked out pretty perfectly. How do you prove causation based on medical treatment that it caused Parkinson's disease? So causation, you're not going to get it from your treating physician, really. We're going to have to get it from an epidemiologist. And as I said, we don't know the exact mechanism by which the paraquat is getting into the brain. We just know it's getting into the brain, and that's what we're focusing on for the MDL. So, we're just going to have to, find the right experts and go with, the experts instead of the treating physicians to really drill down on causation. All right, well, I believe that is the conclusion of our presentation. I hope this has been helpful for you. It's been fun for me, and I appreciate you guys listening. And if you have any questions, please reach out to Matt or to me, and I truly appreciate your time. Thank you very much.